Hi friends, today I would like to discuss with you another significant topic of law known as a precedent or citations. We know that whenever we argue the case as an advocate, we give the citation of the Honorable Supreme Court of India or of the High Court, so that the Honorable Court would pass order in our favor. So, what is the conditions to consider this judgment or citations? Number one, the judgment must be identical and similar to the case in hand. If the judgment is not identical and similar to the case in hand, the court will not consider the judgment. Even if they record, they will say that the judgment or citation tendered by the advocate is at all not applicable to the present case in hand. Therefore, what is the identical judgment and similar judgment? What is the difference between these two? I would like to focus here. The identical judgment means exactly same judgment. There is no difference at all between the earlier case laws and the present case in hand. The facts are also same, the question of law is also same, the substantial question of law is also same. Then the judgment is called identical judgment. And similar judgment is means having same features, having same characteristic, but not exactly like that. It's like as good as. Therefore, judgment either must be identical or similar to the fact in issue, fact in a case, fact must be same or question of law must be same. Then and then the court will consider this. This we know, and I'm going to explain here the part of the judgment. Number one, ratio decidendi. What is obligatory or binding upon the court to consider in the judgment or citation? Number one is the ratio laid down by the Honorable Supreme Court or High Court in that judgment. The ratio means the reasoning provided by the justice while delivering the judgment. The evidence where the law considered by them, the evidence is considered by them, the reasoning provided by them is binding upon the judge while deciding the same. That portion, that part is mandatory. That part is very significant. That is called ratio decidendi. Reasoning. We know that there is a proverb that the strength of the judgment lies in its reasoning. So any judgment which is without reasoning is non-speaking order. Therefore, the power or strength of the judgment lies in its reasoning. That reasoning, why the judge is passing the order in either direction, that reasoning is provided, that reasoning is binding. Whereas sometimes while passing the order or judgment, judges they comment. Sometimes such comments which are not necessary to the arrival of the decision of the court. However, those observation or comments are not having binding force. For example, I would like to give two examples here. A lady judge, while deciding a case under section 376 of the IPC, she commented like, मेरा बस चले तो मैं accused को XYZ सजा दे दूँ. She said that I would have cut the part of the private part of that accused, but that provision is not given into the law, so that such a comments are unnecessary. Even if such a comments are made, judges have power to pass such a comment. They have right to pass such a comment, but those comments are not binding, are not having binding force upon the subsequent judges. I would like to give another example of obiter dictum. Justice Pardiwala, he was Honorable Justice of High Court of Gujarat, he passed some comments and observations. Therefore, the controversy arose. Uh, he said that Honorable Justice said that two things have ruined the country, destroyed the country. Number one is corruption, another is reservation. So there were agitation and some complaints were made against him. However, uh, that has not become the ground for impeachment because that was not the proved misbehavior. So these were the personal comment. These were the comments. By the way, while passing the order, those are not having binding force. These are called obiter dicta or obiter dictum. Number three is principle of stare decisis. It means whenever any honorable high court of any high court has passed the order or honorable Supreme Court of India has passed the order, that judgment is supposed to be alive and having force of law, that need to be implemented, because that is not unless and until it is overruled or set aside or stayed. As long as it is stayed, as long as it is not stayed, as long as it is not overruled, that judgment is supposed to be alive. Therefore that need to be implemented, that need to be followed. It is called the principle of stare decisis. So I have covered this ratio decidendi, which is significant, and obiter dictum and stare decisis. Now, as per Article 141 of the Constitution of India, judgment delivered by the Supreme Court is binding on all the high courts in India, all the tribunals in India, and all lower courts throughout the country. Therefore, in short, the judgment delivered by the Honorable Supreme Court of India is binding on all the country, throughout all the authorities, subordinate authorities throughout the India. And by virtue of the principle of stare decisis, even it is also binding on the Honorable Supreme Court in subsequent case, because unless that judgment is set aside or judgment is overruled or stayed by the higher authorities or larger bench. Likewise, the judgment delivered by the High Court, one High Court, is binding on all the trial courts within that territory. For example, the judgment delivered by the Honorable High Court of Bombay is binding on all the trial courts in Maharashtra, and also binding on the judgment passed by the single judge of the Honorable High Court is binding on the single judge of the High Court, whereas it is not binding upon the division bench of the High Court in subsequent case. A judgment delivered by the division bench of the High Court is binding on the another division bench of the same High Court, as well as absolutely undoubtedly it is also binding on the single judge of the High Court in subsequent case, because that judgment is delivered by the division bench of the High Court. A judgment delivered by the High Court of other states like Karnataka High Court or Andhra Pradesh High Court is not binding upon the judge upon the High Court of Bombay. It doesn't have the binding force, it has only persuasive value. That can be considered, that may be considered, but there is no binding force. There is no obligation to follow it. It may be considered, some principle may be considered, therefore it has only persuasive value. The judgment delivered by the other high courts like a Karnataka High Court or Delhi High Court is also not binding upon the lower courts in Maharashtra like a district judge or court of lower courts like all trial courts. But it may have a persuasive value, it may be considered by the lower courts or trial courts in Maharashtra. Whereas, because it is not the parent high court and the judgment delivered by the high court is only binding on the trial courts within that territory. Now, what Article 142 speaks here, I would like to mention here. Article likewise 141, the judgment delivered by the High Court, Supreme Court is binding on all the high courts and all trial courts and tribunals as per 141 of the Constitution of India. Like 142, these are the extraordinary power of the Honorable Supreme Court and inherent power of the Honorable Supreme Court of India to grant justice, to fill up the lacunas. Such a kinds of powers, extraordinary inherent powers, can be used by the Supreme Court to fold the relief, to mold the relief, the thing which were not prayed, that also can be granted by the Honorable Supreme Court of India under Article 142 of the Constitution of India. To fill up the lacunas, even if some defects are there in the law which could not provide the remedy or relief to the petitioner, still Honorable Supreme Court of India can go beyond that, can fill up the gap and can grant the relief under Article 142. There are three important cases which I would like to cite here in nutshell regarding 142 of the Constitution of India. Number one is a case of Ram Janmabhoomi bracket Babri Masjid case, wherein the party who were belonging to Muslims, they never claimed land from the Honorable Supreme Court regarding that. In that case, however, the Honorable Supreme Court has granted some acres of land, I think 6 acres of land to them, though it was not prayed specifically. Therefore, to give some justice to balance the same, the court may do some extraordinary things which is not provided under the law. Court can also fold the relief. It's to give a complete justice. And another case laws of Bhopal gas, wherein the Honorable Supreme Court of India has directed to forthwith deposit the compensation. Those were in the millions. Otherwise, to claim that compensation due process of law has to be there, that would have consumed the time. Therefore, Honorable Supreme Court has directed to immediately, forthwith, deposit that amount of compensation. So, another judgment of Shilpa Srinivasan, wherein the Honorable Supreme Court of India has waived the cooling period or statutory period of 6 months for granting the divorce, though it is statutory condition under the law. So, to grant a complete justice, to fill up the lacunas, the Honorable Supreme Court has got the inherent power which can be used under Article 142 of the Constitution of India. So, such a judgment is also binding on all high courts in India, all trial courts, all tribunals also, and also Honorable Supreme Court also in subsequent case, and because unless the earlier judgment is overruled or stayed by the Honorable Supreme Court of India or by its larger bench. Whenever there is a judgment delivered by the division bench and the same fact in subsequent case, the similar case has come to subsequently the Honorable Court feels that the earlier judgment was not proper, it has not followed the law, it need to be corrected, reviewed, then it must be referred to constitutional bench, likewise 5 judges, so that the law can be made very much clear. Otherwise, the earlier judgment delivered by the division bench of the High Court is binding on the another division bench in subsequent case. I would like to also discuss with you another point here. Judgment per incuriam. We also hear that judgment per incuriam. What is that? Once the judgment, whenever the court while passing the order has ignored this law or judgment is made against the express provision of the law, or it has ignored the earlier judgment of the court of the same bench or of the higher authority, then it is called judgment per incuriam. For example, Honorable High Court of Bombay has given a judgment, but while deciding subsequent case by the other bench, they have forgotten the earlier judgment, or they have passed the order against the specific provision of the law, that is against the law, or they have forgot to follow the law laid down by the Honorable Supreme Court of India, then such a judgment is called judgment per incuriam. Such a judgment per incuriam need not be followed by subordinate authority or anyone, because that has ignored the law, that has also ignored the earlier landmark judgment of the same higher authority or same authority. It is defective order. It's per incurium. Hope that I have addressed you regarding this. Perhaps many points have forgotten. We may cover the same in this next lecture also. It was my uh, intention to express and to give clarification regarding the precedents in judgment, so that the new coming lawyers, fresh lawyer, may hear this video, they may watch this video, they may learn some many things from this. Thanks to hear me, Advocate Shahid Ali Ansari, practicing advocate at High Court of Bombay.